Hello, everybody, and welcome to yet another installment. I think this is our third 2-hour webinar since the coronavirus started.
Chapter 3.
Chapter 3. This is Chapter 3 of our update on the COVID-19 and what's going on. This one's called the burning issues. It's a day-to-day changing environment, sometimes radically, and we're all dealing with it all the time. So we're trying to keep everyone as informed as we can, keep ourselves informed, and tell the world about it. So we're going to give you the updates since last time around. We did an expose on the workers' compensation issues and the employment law issues. This is me and Eric. I'm the general managing partner of Michael Sullivan and Associates and the author of Sullivan on Comp. And Eric is the managing partner in charge of our employment law section here at Michael Sullivan and Associates. Hi, Eric.
Hey, everybody.
Yeah, so you heard us last week if you listened in, and if you didn't, you can check us out on our firm website, Michael Sullivan and Associates, or if you're a subscriber to Sullivan on Comp and you want to get MCLE or CE credit for it, you can watch those videos there. But anyway, we talked in depth about what was going on, and in the last week, so much has happened, and I've had so many more thoughts about it than I did last week. And so it's not just updating, but sort of exposing the changes and then thinking more deeply about the different issues that arise and how we're seeing them manifest.
Yep. And I mean, the reality is, since we first recorded Chapter 1 of the COVID-19 issues, from the employment law perspective, many of the FFCRA, what we understood what the FFCRA was supposed to be about, has been updated, changed, reevaluated, which is why when I speak a little bit later, I'm going to get a little bit into the nitty-gritty of FFCRA and breaking it down.
I love it when you use terms like FFCRA as if people understand, as if I understood what that was.
Well, we're going to get there, but just so everybody knows,
what is it?
It's the Families First Coronavirus Response Act.
Right, so that's one act.
It's one act that has a lot of subparts to it, but
Right.
what we're going to be talking about are the two subparts, which are the EFMLEA, which is the Emergency Family Medical Leave Act, and it's another portion of the regular FMLA, and then there's the Emergency Paid Sick Leave
Right,
Act.
so there's sick leave and there's FMLA expansions in both areas.
Correct.
Yeah, and there's a lot more to it. As I understand, there's a bunch of new regs that got posted in regards to the
Last week.
Family leave part.
Last week.
Yeah.
Many new regs and interpretations
Right.
of that, and we'll get in a little bit into the Cal-Warren Act as well, but mostly about leave and how to handle it and the integration of California law as well.
Okay. Yeah, so we're going to get into all this stuff. I'm told that I'm supposed to tell you that if you want to check out the slideshow, you can print it. There's on your toolbar. I think it's under presentation or something like that, and you can print it. Is it
Handouts?
Handouts, yeah, handout C. Handbooks, handouts, very good term to use.
Yep.
So anyway, yeah, so you can check that out and print it if you want to. You can follow along as you go. Just to get clear, I wear a couple of different hats, and sometimes I put on the black hat, and sometimes I put on the white hat or the gray hat. So I run Michael Sullivan and Associates, and we're 80. I think the last count was 82 lawyers through 9 offices in California, primarily doing workers' compensation. But Eric has led up for the last couple of years our developing employment law section. We also do immigration law, insurance litigation, civil litigation, subrogation. We've had an expanding firm. But I'm also the author of Sullivan on Comp. And as we present these slides, you may be a subscriber to Sullivan on Comp if you're listening to this. It's a comprehensive treatise covering all of workers' comp law in California. I really think it has become the standard text in the industry. And if you're a subscriber, we have the sections at the bottom of the slides that pertain to workers' comp that describe, if you want to read in depth about something, you can go to that section of Sullivan on Comp and read it. So today is a presentation of Sullivan on Comp. So I'm trying to keep my defense attorney hat off and put my Sullivan on Comp hat on and give a complete exposition of all the issues and all perspectives and arguments that we've made in regards to the issues that are arising globally. This is really less of a time of advocacy and more of a time of just understanding and discovery about the parameters of the debates that are going to arise relative to this coronavirus. You know, look, like I said, it's changing constantly. Maybe I can give an example. In the first one we had, I said, what's the big deal if coronavirus is work related? And I said, well, it's a big deal because people are going to, normally when people have the flu, they get better. They don't need benefits, right? Not really. So you don't see these kind of cases. But with this, people die. So they're going to be death cases, and that's important. And so it's the TD issues. And then you know what? I thought of about 80 different reasons why that statement was overly simplistic over the last week. I mean, my God, they're asking for a presumption that if you're working, coronavirus is work related, because after all, you're essential. You're not part of the general public, right? You're special, and you're put at increased danger of getting it. So everyone who gets coronavirus should be work related, right? And then they want a presumption for the stress and the psychological injuries that come from this. And I thought, oh my God, everyone's working at home. They're stressed. Is that a personnel action? What about aggravations of underlying conditions? What about whether industrial or not? How does that play out? And I realized that this is a huge area with all kinds of issues, and there's going to be a lot of claims and a lot of really hard to understand things. So I'm sure it's the same experience you have with the employment law side of things.
It is, and things have changed. We anticipated how this was going to be dealt with based on history of employment law in California and through the ADA. One of the things we talked about is, usually you would never want to be able to take a temperature of an employee and we went into the categories of when you can do something as invasive as that, which is categorized as direct threat. When we broadcasted chapter 1, it was not a direct threat, and you shouldn't be doing it.
Right.
Days later, the EEOC sets out a guideline through CDC saying, we consider this a direct threat. Employers, under certain circumstances, you can take the temperature of employees, which is unprecedented. It's never been done before.
I haven't done that, by the way.
Thank you.
You're welcome. But anyway, yeah, so it's really moving, and it's not just that things are changing, it's that our thinking is becoming deeper and clearer, and the circumstances and the issues are changing. So here's what I'm going to do. I decided I was going to do an exposition on the AOE, COE issues, the compensability issues, as well as update everyone with what's going on. But I realized, no way. Our first version of this was so many slides, it would have taken almost 4 hours to do. So here's the plan. Eric is going to break out, and when we need, whether it's weekly or biweekly or whatever, an employment law webinar, he's going to give it. What I'm going to do, I'm announcing this, is at 12 p.m. every Thursday from now on. I'm going to do an hour, an update, followed by a deeper exploration of a key subject. So we'll start with things like provision of the claim form and when we have to and when we should, and go into benefits administration, but also home as a second workplace is a whole separate topic. The basic standard and how it's played out and will play out with coronavirus and the presumption, things like this. I'm going to work through piece by piece, the complete exposition of all of the issues that surround the compensability of coronavirus and how it's playing out in California. So every Thursday for an hour at noon, you'll be getting notices, but you're hearing it here first now. I wanted to mention that I'm recording this the day before it's published. The first time we did this, we had a real problem. It's horrible because we had like well over 1,000 people trying to listen, and we broke the computer.
Almost 3,000. We broke the internet.
Yeah, we broke the internet, yep. And so no one could hear us in parts of it. So we recorded it, and now it's on our websites, and you can listen to it. But we decided just to record this instead of doing it live. That way we wouldn't have any more of these technical issues tomorrow. Right now it's towards the end of Tuesday, and it's coming out tomorrow at 10 p.m. So if you're listening to this, we're talking yesterday. So if anything dramatic happened, we didn't forget about it. We just
it didn't happen yet. Wednesday.
Today is Wednesday, tomorrow's Thursday. I knew that. It's certainly not like I'm sitting at home in my pajamas and the days are all blurring.
We actually fully dressed up today.
Yeah. Oh, I did take a shower yesterday. I felt pretty good about that. That's a little too much information.
Yeah, was. Keep going.
Yeah, so we're going to edit that one out. See, that's the benefit of a pre-recording. This is what we did before. Part 1 was workers' comp liability and employment law for coronavirus. And then the second one was is you, Eric, and Keith Figgins
Yep.
talking about the interactive process and reasonable accommodation, which is a big part of all this.
Yeah, the return to work overlap, which is another 2-hour presentation, and we peppered in how to handle it with COVID-19. And it's still seems to be tried and true, but there's going to be a few changes, which I'm going to mention in this chapter.
Yeah, it's a hell of a topic, and it's a hell of a time, man. It's just historically weird.
Yep.
Yeah. Okay, so here's what we're going to do today. We're going to talk about an update. We're having trouble in practice, the things that are going on as we try to handle cases. You know, and in addition to being a lawyer, I'm a business person, right? So I run a law firm, and I talk to my managing attorneys all the time, and all the attorneys here. We talk about the different things that are happening, appearances of the WCAB, virtual depositions. How the heck are we going to handle QB evaluations? And there's this issue of time limits for UR. We can't seem to get millions of letters out a day without a machine, but we're all at home in our socks. So how's that going to work? I was gonna, like I said, I was really going to run through a whole spectrum of issues regarding the compensability of coronavirus and the issues surrounding that. I'm not going to do that. I'm going to do that over the next few weeks, as I mentioned earlier. But I am going to give a spectrum of the issues, kind of like identify the different parts, the different things that are going to become issues and why they're issues. We're going to go through that, so at least we have the lay of the land. And then finally, when I'm done talking, why are you smiling? There's nothing funny about that.
Because it won't happen.
Yeah, okay. Employment law with Eric. He's gonna keep us up to date on all the different. See, there's all the little letters and what they mean all in a row. And so he's gonna walk us through that stuff and give us the changes, the current issues, and his thoughts. Sound like a plan?
Sounds like a plan.
Okay, let's do it. So we did include a introductory slide here. You know, it's hard to keep track of the stats in coronavirus. Somebody was saying they're hoping it would peak this week, that the stay-at-home thing is going to level it off, but it has been growing. COVID-19 is the name for the newest coronavirus, right? They manifest differently. This is the new one, as we know. It started in China. Most people don't know they have it because the latency period is 2 to 14 days. This is the last I heard. And it seems to be at least 10 times more lethal than the seasonal flu. Although the last numbers I saw, and I think Eric, you were saying it's getting to the point now where everybody knows somebody that's got it.
Yeah, we're at that stage where most everybody at least knows somebody who has it or a family member who has it.
Mm-hmm.
And it's getting to that point where we all know somebody and we're actually impacted.
Mm-hmm.
And it's going to, it's going to get worse before it gets better.
For the majority of the population, the fatality rate is well under 1%. But another problem is that about 1 in every 5 people who need it, they have to go to the hospital, and a lot of them are on respirators. And so we're going to run out of respirators. We're going to run out of hospitals if everybody gets it at once. Hopefully there'll be a vaccine, but that takes a long time to develop. And so we're in danger of, having too many people sick at once and then having people die because of it. And we don't have enough equipment, enough hospital workers. So we're trying to slow it down. We're all living in this world, and we all know how bad it is. So I don't want to beat the subject to death, but that was an introductory slide. And then, of course, we had our executive order that came from the California governor on March 19th, and he says everybody has to stay home or in their place of residence, except for what are deemed to be essential activities, right? So I think, Eric, you were saying that they're actually handing out fines now for people that are not wearing masks in public.
Yeah, well, LA County has a requirement to wear masks that came out and is going to be fully implemented by Friday. But I've already heard of people being in public without masks in LA anyway. This is the only place I know this is implemented for not wearing a mask in public. But these essential services and workers, that becomes trickles down the line of there's a lot of companies that also provide services for those essential services. So what we're recommending for these businesses is that they have a note for these businesses to say, yes, we need this particular business in order to stay afloat, in order to keep our lights on, to be that essential service that you need. And if you don't have those notes, there are companies that are being shut down.
Well, not only that, but I heard the mayor of LA saying we're cutting off, we've warned for the companies we've warned, we're cutting off water and power.
Yep.
So it's no joke. It was either him or the governor who was saying, hey, this isn't a request, this is an order.
Yeah.
So we're under martial law here, not martial law, but I shouldn't say that, but we're under orders from the government to stay home. And
well, when essential services were initially listed, there was a lot of employers who were saying, hey, I'm going to take the risk. I'm just going to stay open.
Yeah.
And the penalties for that are getting more and more severe.
Right.
And they're actually becoming more and more frequently policed. So, so if you do so at your own risk with potential fines.
Well, it didn't make it onto the slides because it didn't directly pertain to what employers are doing, but I think, they have the severance, what do they call it? The money they're giving to all the small businesses.
CARES Act?
Mm-hmm. The CARES Act, and if you don't know about it in your small business, you should be familiar with it, because the way it's fundamentally working is the Small Business Administration will give you 2.5 times your monthly payroll.
Payroll cost, yep.
Yeah, your payroll cost, with workers capped at $100,000 in wages for purpose of the calculus. And so that's a lot of money for a lot of people. So if your payroll is, $10,000 a month, they'll give you $25,000, and it's forgivable if you spend it on payroll. The idea being that you keep your business open and keep people on the payroll. And of course that means different things for different businesses, but it's pretty crazy. They didn't really know how they were going to do it, and a lot of people spent all last week trying to figure out how even to apply and fund. But it's really important, and it's a big deal for a lot of businesses and a lot of workers.
This is it's a life preserver for many of the small businesses. When we say small business, it's 500 or under for employees. And this could make all the difference between shuttering a business and it staying afloat. And it's 3.5 billion that's out there, and it's first come, first serve. So
no, it's 350 billion.
350. I'm sorry, I said 3.5. 350 billion.
One of the senators was saying we got to put more money in this.
Which they say they will. They say they will, but we don't know.
And who knows how long this is going to last? I mean, I put down there, how long is this going to last? And the answer is we don't know. Anyone who tells you they do is making it up, and it also depends on how long we can tolerate it. This staying at home and watching our economy just go away, right? Yeah. So I myself have told everyone at our law firm that we're going to do this at least through April. And we'll make a judgment then, but I have a feeling it's going to be longer. And one issue that comes up is, what if the kids are still out of school and I'm supposed to be back at work? And so we're going to, as a firm, we promise to make reasonable accommodations for that. It's going to be week by week, day by day judgments about what's going to happen. So I think we just need to sort of put our heads down and get through one day at a time.
Yep, together. And a lot of this is what's the right thing to do. But also when it comes to how these laws are going to be interpreted, what we keep hearing from EEOC and the Department of Fair Employment and Housing is we need to be flexible. We need to be flexible with our employees, where we're used to be kind of strict on, hey, you need to get us a medical note. Hey, you need to be backed by the state. They want us to be significantly flexible when we administer these policies. And we have to keep that in mind because they're already putting out those notices.
Yeah, so don't be a jerk.
That's
but also don't take advantage of it. And
yeah.
if you're an employee, and don't be a jerk if you're an employer.
Yep.
So
I like it.
It's resulted in a lot of trouble in practice, and this is, I think, if we're going to update you what's going on with coronavirus, we have to talk about this stuff, and we will talk about it in more depth. The WCAB has shut itself down, and we're going to talk about it, but we haven't had any hearings except for expedited hearings this week and the week before. And then next week, hearings are all going to be by phone. There won't be trials. There won't be lean hearings. So that's gone on. Virtual depositions, we're just starting to do those here at the firm. Obviously, there's good and bad things about that. And you have to decide, what you want to do. Medical legal may be the worst problem of all. We're going to talk about that in some depth. because, you know, without a physical examination, what are you doing, right? But on the other hand, without a med legal, what are you doing with your case? So it's really problematic. And finally, as I mentioned, UR time limits are a big issue. I did want to mention something that came up yesterday that didn't make it on the slides, is that the DWC announced that you can now file with the DWC documents by email. Now, look, it's important to remember that there's 7 commissioners, right? And that is the Workers' Comp Appeals Board, and they're in San Francisco, and they're in the same building as the local San Francisco office. There's a difference between the appeals board and the local offices. We tend to think of the local offices as the board, our local board, where we go. But those are just the local offices, and all those judges stand in the shoes of the 7 commissioners. All they're saying is, if you're filing documents with the WCAB itself, which is usually an appeal of some kind, petition for disqualification of a judge, petition for reconsideration, petition for removal or an answer or reply to those things, those can be filed by email, and they actually gave an email address. But they said you can't do that at the local levels for things that can be filed through jet filing and e-filing, unless, you know, coronavirus situation compels it. So they did put that out there, and that came out yesterday. I didn't make it to the slides today, but I just want to throw it out there because it's one of those things that's daily changing. We sent a Sullivan on Red Alert about it, so if you're listening to this, you probably already saw it.
And from, I don't really get into this later, but just from a civil and employment law perspective, the way civil cases, employment law cases are handled are universe apart from how workers' comp are done. But just for where we are, also, most all hearings, as opposed to putting them on court call, have simply been canceled. So all of my litigation hearings, my trials, everything has been taken off calendar through May.
What about like MSCs?
MSCs off calendar.
Off calendar.
Everything is off calendar, at least for now through May. Everything's been scheduled for June, so June's going to be a busy month. But that's the way they're handling it now. Now, there are administrative formats, which is the Equal Employment Opportunity Commission and the DFEH and the Labor Board. They're still going, and they're still doing investigations. They're still doing mediations. They're still requiring filings. So that hasn't stopped from the administrative level, but from the civil level, everything is pretty much at a standstill.
Yeah, all the cases, all the trials just got automatically continued, and I think that's going to continue for some time. The WCAB has only given us guidance week to week, and so we're just going to have to keep doing that for a while. Let me run through it. Their initial en banc decision has been 2. The one I talked about just now was the second one about the direct filing. This was the first one, which is much more comprehensive, and I laid out what it says. Here's an en banc decision of the WCAB, and it's interesting because what they're doing is they're setting aside regulations. Now, do they have the authority to do that? The answer is yes, so they say, because of the general constitutional authority to do everything necessary to make it expeditious and to get benefits delivered, but that's an open issue. Anyway, in any case, no one seems to be contesting these actions right now. They're obviously necessary in the present environment and accordingly probably reasonable and sustainable. But anyway, they're suspending dismissal of the application or lien claim, basically dismissal of a case for failure to appear, right? So when you don't show up for court, you can't be dismissed. If you don't show up for an MSC, they won't issue a notice of intent to dismiss. They'll just set up for trial, or they'll take it off calendar or kick it over. The judges and arbitrators have unlimited extension of time within which to issue reports in response to recon and removal. So when you appeal, the judge is supposed to get a response out within a certain time, and they don't get paid if they don't. Well, now they have unlimited time, which seems a little stupid to me because after all, they're not hearing cases, right, as much as they used to be. But anyway, they suspended the requirement that 2 witnesses sign a compromise and release. You don't have to do that. Signatures on all forms may be electronic. So you can get your settlements done without any witnesses. And suspension of requirement for service by mail by the WCAB, not the parties, but the WCAB. So they don't have to mail anything. They can do it electronically with or without the party's consent. The board can do that. So these things have all been suspended. All filing deadlines are extended to the next day where the district offices are reopening for filing. So the obvious intent here is to stop people from going to the district offices. And at the same time, preserve everyone's right to pursue or appeal an action. They're not going to close anybody off from a case because of lack of attendance. So although you don't have to sign the CNR, the board allows settlements by parties who are required to stay home, but they want um, they want the CNRs to keep coming in. So we've had two phases of hearings and how hearings are handled. The first was on March 16th when they originally announced a modified hearing calendar. And then on April 3rd, we got another announcement extending the original set of circumstances through April 10th, and then announcing new procedures effective April 13th, 2020. So I'll run through those for you here. So from the 6th to the 10th this week, they're continuing to hear expedited hearings in person if people appear at the district office. Now, expedited hearings, you know, they're only good for a few issues. This is one of the things I asked new lawyers that are applying to work in my law firm. What are the proper subject of an expedited hearing? And by far the two most common are medical treatment, need for medical treatment, and need for TD. These things have to be heard. They can't be heard, at least in the DWC's opinion, virtually. So if you have an expedited hearing, it's on calendar, you can appear. But of course, if you don't appear, they're going to kick it over, right? Because they can't dismiss a case. If the defense didn't appear, then they might be able to just grant it, right? Subject to review. But if an applicant didn't appear, they'd probably just kick it over. But anyway, those are the only live hearings that have been happening in the last 2 weeks. And so also there's status conferences, MSCs, priority conferences. For this week and the week before, it was only allowed via court call. If the parties don't appear via court call, then it gets continued and notice is given. And guess what you do? Well, if you want a continuance, you don't appear, right? One of the attorneys in my office had the idea, and it was really hard because court call was really inundated. So were the judges. One of the attorneys in my office came up with the idea to call the applicant's attorney before the court call, get it going, and make sure you coordinate the connection so you don't miss each other. Most everything got continued. There's just been a few court call cases. Only a very small percentage of these things actually happened. Trials, lien conferences, not heard, will be continued. And what the board did is they just took them off calendar and sent notice and to the parties as to the new date. So that's going to cause a lot of, conflicts on calendars, but that's what had to happen. It's happening till Monday. And then of course, if you're at the WCAB, you're supposed to stay 6 feet away from each other. So the district office is closed through April 10th. All district offices are closed, and any filing deadlines are extended to Monday, April 13th. I think about how you have a year to file the application. Otherwise, you violate the statute of limitations. And I guess they are going to extend that. That might be an issue down the line, but you can't file anything physically. So all these hearing reps that make their business walking through settlement docs, walking through, anything, especially settlement docs, they can't do it. They have to submit it. They won't accept walkthrough documents. They have to utilize EAMS, but you can follow up aggressively with EAMS, and they're getting handled pretty expeditiously. So that works pretty well too. Some people are mailing them, but I mean, who does that anymore, right? But then effective Monday, they're going to do it differently. See, now, when I was talking about it with some of my friends that run law firms and workers' comp and risk managers, I said, we need an emergency regulation because, what's happening is parties are not appearing to court call if they don't want the case to be heard, if they want to kick it down the road. So it became a strategic thing. And I said, if there's no teeth to failure to appear, then this whole system's going to grind to a halt. So I want an emergency regulation passed that says you have to show up for court call. Well, it turns out that they had a better idea, which is they're just going to hear all these conferences by telephone. We just got this a few days ago. They said, okay, so what's going to happen for MSCs, priority conference, and status conferences is you're going to call this 800 number and at a certain time, and the clerk is going to answer. And then that clerk is going to put you on with the judge or send you an email as to the right time that the judge will be available. Now, how is this going to work, right? At first I thought, hey, this isn't right because the statute says you have to appear for an MSC. If you don't, you get dismissed. But of course, they suspended that regulation that you get dismissed, so you wouldn't get dismissed no matter what happens. But it says that you have to appear. But then when I actually looked at my own book, Sullivan on Comp, I realized that appear is not defined. I mean, appearing telephonically may indeed, it's something I have to research, may indeed be a valid form of required appearance. Of course, if you, before coronavirus, if you said, well, I'm not available, but I'm appearing by phone, you would get the judge, doing all kinds of terrible, horrible things to you. So maybe in that environment, that didn't count as appearing, but maybe in this environment, it does. In any case, this is what we're doing, folks. We're getting on the phone.
And appear for civil cases has always been also court call.
Oh, really?
So appearing by, so if they want to extend the definition, it's been for a decade. Appearing can be in person or it can be by phone if approved by the judge.
I knew there's a reason we kept you around.
Yeah,
You're
I
so
have
smart.
a couple of
Well,
uses.
actually, that helps to know, because that means that what they're doing is probably legitimate. It does count as an appearance. But see, here's the thing. You have to appear, right? They can't dismiss you, but you have to appear. And the regular rules apply. So it's no more court call optional. It's like, hey, these conferences are happening, and even expedited hearings are happening telephonically, and you have to appear. And if you don't, then the regular penalties, absent dismissal, will apply, including setting up for trial. Supposedly, the regular hearings. I mean, they can sanction you, they can set up a trial, they can do discovery cutoffs, they can do whatever they want. It's just a telephone thing. It's not a physical appearance thing. So there's gonna be a toll-free line, and there's gonna be a list of conference line numbers. It's just being developed right now. It's gonna be posted on the DWC's website prior to the effective date. So nobody, I mean, this is gonna be the Wild West next week. It's gonna be weird because we're not used to this, and we don't know all the glitches that are going to occur. So you call, and then when prompted, you enter the access code. I guess that's when the judge is ready for you. I think it's still a really good idea to get on the horn with the other side well before this kicks in. It always has been, but now it really is, because you get there and you're talking to the judge before you're talking to each other. And that's not what it works in court. You got to talk to each other and then go see the judge, right? So I think responsible practitioners should set that up on calendar before the court appearance, if you can get the other side to respond to you, get that set up, which maybe you can, maybe you can't. Anyway, staff are they going to be on hand to guide you as to who to call when, and send emails. And all trials and link conferences, again, are continued until further notices. There will be no in-person hearings. So again, no trials, no link conferences, which is a bummer, because without trials, it's hard to resolve cases. Effective April 13th, the DWC will reopen for filing purposes, but they're not going to be there. You can't physically do it. They only accept it by EAMS or jet file or by mail. So what does it mean that they're reopening for file purposes? I don't really know, because it seems like it's the same thing that they've been doing the whole time, although maybe I'm missing something. They won't accept walk-in filing or walk-through documents or in-person requests. So they're not really open for filing purposes any more than they were before. And they have this number here for injured workers who need to use INA officers, because INA officers will not be seeing people in person either. Effective immediately, the DWC will accept an electronic signature on any settlement documents, pleadings, petitions, or motions that are sent to the district offices or filed in EAMS. So electronic signatures are continuing to be allowed, as they were from the original en banc decision. The commissioner's office, remember what I said, the San Francisco commissioner's office with the 7 commissioners sitting on high, is closed to the public for in-person inquiries and requests until further notice. So it's closed down, physically closed down. You cannot go to the board. You cannot go to the district offices. If you do, you can't do anything there. It stays virtual, and that's our reality as of Monday. Now, how long is that going to last? We don't know. We don't know. All we know is this is what's happening Monday, and we can probably suppose it's going to be that way for all of next week. But who knows? Maybe we'll get another DWC directive. Sooner or later, they have to figure out a way to put something on for trial. But the question is this going to last a month, or is this going to last 9 months? And I don't think anybody knows the answer yet. So what they're doing is they're just kind of sticking their fingers in the holes and in the dike, and they're just trying to keep it all from falling down, keep the cases moving, without committing to a permanent course of action. Another thing that we're doing is remote depositions. Now, I went around the firm and I said, look, just because you're doing, you got a depo set, doesn't mean that you just continue it, right? What I told my lawyers is, and I think what we've been doing is, we look at the case and see, how important is a deposition taking place and now instead of 45 days from now? How important is that? Obviously, there's cases with the 90-day denial period at issue. There may be other reasons why a deposition is just important. There's not just depositions of applicants, right? There's also depositions of doctors. And you have to weigh how important it is to move forward versus what you lose by not doing it in person. So what do you do? It's tough. I personally think the deposition is the most important aspect of discovery from the defense attorney's perspective. A lot of people think that they're stupid and a waste of time, but I think if done properly and if they're thoroughly researched and investigated before they happen, they really should be the defining moment for a case.
And in civil litigation, there's unquestionably the most important aspect of discovery.
Well, you know what? A lot of workers' comp lawyers suck. I mean, I just said it there. I said it, and I know because I interview them all the time, and I will hire maybe 1 in 3, and then I'm hoping that I got a good one. And of course, there's quality control and supervision, but they don't. Not all of them are good litigators. All they know how to do is cookie cut, and that's the problem with this industry. But if you set your system up properly as a law firm, that doesn't happen, when it does happen, you know it and you fix it. But anyway, I just think the depot is so important, and it's really hard to put. It's hard to judge how important it is to be there physically. For me, it's vital because the cross-examination process requires the nonverbal realities that just take place between people. There's interpreters. I mean, if an interpreter's on a different site, the court reporter's on a different site, it's just, it's crazy.
I think no matter what,
it's better in person for sure.
There's no question about it. I think under the circumstances we're in, it's about strategy. For you in the workers' comp arena, there's a lot of deadlines and triggers that are involved. In my world, for civil litigation, most everything has been pushed. Mm-hmm. So my deadlines have been pushed. Mm-hmm. And if I have the choice, I'm taking I've had plaintiffs' attorneys approaching me going, we'll do this by video. My response is, heck no. I want to be there face to face with your client. Right. Pushing the document across and seeing I want to be there. Mm-hmm. So for me, I won't do it unless I absolutely have to.
Yeah.
But I'm in a position where I don't have those triggers and deadlines that are in the workers' comp.
Well, you got to understand too that a lot of workers' comp cases settle quickly at the very beginning of the case. To eliminate the deposition is to eliminate an opportunity to do that. Yep. So a judgment needs to be made. It should be made with the client. And of course everyone has to agree. If the applicant attorney doesn't agree, it's just not going to work. We've actually changed our depot notices, our default ones that we send out. Instead of saying we're doing the depot on the stay, we're saying we're doing the depot on the stay. But if the coronavirus thing is still here, then we may do it remotely, right? So it's requiring judgment. We're seeing most of our depots get continued, but we've done a lot of depots remotely, and we've even done doctors' depositions remotely. So anyway. The other thing about remote depositions, which I think does require DWC action, is the Code of Civil Procedure that says that the applicant has to be there with the court reporter physically when the deposition is taken. It says that in the Code of Civil Procedure. Any person other than the deponent may attend a deposition by telephone or remote or electronic means, implying that the deponent can't take it by telephone or other remote or electronic means. Now, look, the Code of Civil Procedure applies to workers' comp only because the judges say it does. Actually, no, I think 5710 actually says that you take it as per you would in a civil case, something along those lines. We did a big analysis of it in the House. I think we actually sent a notice out to the industry which said, you know what, under the current circumstances, it seems like it would be reasonable to say that the parties can waive this requirement, even though it's a statutory requirement. The workers' comp overarching jurisdiction does supersede the Code of Civil Procedure. They can do anything they want if it's to make it expeditious and fair and to get benefits distributed. So this may be challenged at some point, but I think it might survive. I think it would go a long way if the DWC would put out a bulletin saying no one has to physically be present at a depot if all parties agree, despite whatever the Code of Civil Procedure says. Anyway, we're making sure to get a written stipulation that everyone can do it remotely ahead of time, every time we do a remote deposition. I think that's an important part of the practice. I think I just talked over my next slide. But we are in an emergency situation, so I think at the end of the day, that's going to fly. I got ahead of myself. Sorry. Now, the next issue, telehealth. I think this actually pre-existed. It actually pre-existed the corona health problem. We put the relevant section of Sullivan on comp there at the bottom of these slides in case you want to read over it, but we have a section on it where we discuss telehealth. There have been cases that approve of telehealth even before the coronavirus. You don't always need to physically see the doctor. Sometimes you're on medication and you're just getting a checkup to see if you still need it or running the course or whatever. A lot of different reasons. Telehealth, of course, is taking on a much more important role in the present environment. So there's a stay-at-home order. So unless it's an essential activity, you're not supposed to leave home. Now, essential activities is one of those words that lends itself to multiple interpretations. You see that a lot as a lawyer, right? It's like, what does that mean? And the answer is usually you think it means what inures to your benefit at the time. That's the way it works, and then lawyers fight about it. Healthcare providers and hospital personnel are part of the are essential, obviously, for medical services generally, but not all medical services are essential. So how does that work? Whether or not it's essential to appear at a doctor's office in workers' comp depends on the needs of the worker and employer, the stage of the case, and the type of the appointment. But I think these services should be considered and are being considered a lot more these days because of this crisis. We have the definition of it up here. It's the mode of delivering healthcare services via information and communication technologies, right? And to facilitate what you're doing at the appointment. And it enables the physician. You can use video conferencing, video calling, or similar technology. I know people that would do this. I know, like, I'm a member of Kaiser, and they, I know that I think that they were doing it in some cases. People that just didn't need to be seen physically. But you got to make sure, if you're a physician, to inform the patient about the use of telehealth and get consent to it, right? You don't want to not see somebody physically who needs to be seen physically, or maybe you don't know that they need to be physically until you talk to them and you realize that they do based on what they tell you. So, like with everything else, if you're operating outside of the normal system, written consent is ideal. But what about medical legal evaluations? That's different than medical treatment, right? Medical treatment is seeing a doctor for purposes to cure or relieve an industrial injury. And that's medical treatment. You're going there to get better or to not hurt so much. Medical legal evaluations are done in order to ascertain an answer to a legal question, which necessarily involves medical considerations. So, how did you hurt your back? Did you hurt your wrist? Did the computer at work hurt your wrist, or were you too busy beating your husband? What caused it? That might be one. Or are you temporarily disabled from work? What are your work restrictions? These are medical legal issues, and we have a whole system. Everybody knows this. We have a whole QME AME system for the med legal process. In some instances, we did a deep dive on this in Sullivan on comp, because sometimes a treating doctor can be considered medical legal and treating, like in a final P&S report where they give medical legal conclusions, but by a treating physician. Anyway, mostly it's AMEs and QMEs. Now, if you look at the regulations, they require face-to-face time with the injured worker. That's a requirement of the med legal process. And without that, it's a valid grounds for objection to the report being valid. But, I thought about this one too, because what is face-to-face time, Eric? What is it really?
Is it Zoom? I don't know.
Is it Zoom?
For me, if I'm sending somebody to a medical evaluation in my world, I don't want my doctor doing it by Zoom. I want, them evaluating the plaintiff directly.
Yeah.
There's so much you don't get from. Zoom's great for doing some conference calls, but doing a full medical evaluation, I wouldn't be a fan of that.
Yeah, I mean, generally, it's not allowed. I argued about this with my group of friends that discussed if there should be changes in legislation. QMEs and AMEs are getting rescheduled all over the place, and it takes forever to get in to see them. And there's statutory timelines that if they don't schedule within, you can get a replacement, right? All these things are real. And I said, hey, this wheels of justice must not grind to a halt. We must have some emergency regulations. I want all these emergency regulations. Probably all of them are a bad idea, but I said we got to do something. We got to have some rules here. We got to like have some situations at least where the QME evaluations take place and it's not a physical contact, because what if this thing goes on? What if we're sitting here talking about this next October and we're still QMEs are refusing to see people. People are refusing to go to QMEs. I mean, it's not like you need a judge to order someone to go to a QME during a pandemic, and you're not going to get a judge to order a QME to see someone during a pandemic. So they all have to consent anyway. But so how are we going to do this? We can't just not do this forever without QMEs. We're never going to move these cases. And people are invested in moving cases. Applicants need resolution to their issues. And insurance companies are built based on financial models, predictive models. Premiums are calculated accordingly. What we don't need is all the insurance companies going bankrupt like they did in the late 90s or whatever that was. And we don't need is people not getting benefits because they can't get a QME evaluation. It's a real problem. But here's the thing. A lot of my clients don't want it. They don't want that because how do you do a QME evaluation, even a psych evaluation? I mean, physical examination requires measurements of physical maneuvering of the body, and it requires a lot. So, how do you do that? The answer maybe you can't do it effectively. So we don't have to know. We got a little bit of guidance from how am I doing on time? Am I way over?
Nope, we're good for now.
For now.
Depending how far you have to go.
No, I'm doing terribly actually.
That's okay. I'll catch you up.
No, yeah, okay. Anyway, so the DWC strongly recommends that it came out and said, okay, we're going to allow this. We're going to allow telehealth QME evaluations, but we're going to say all these things about it, which means you can hardly ever do it. They're able to participate without violating the stay-at-home order. The medical issue, a dispute is determined to be essential to their benefits and must be addressed no later than May 1st, 2020. So unless it's essential, just continue it. That could include AOE, COE, termination of benefits, or work restrictions. There's a written agreement among everybody. The evaluation is consistent with appropriate medical practices and ethical considerations. I mean, these are broad-based statements, right? They're saying we should, if you're going to do it, it should comply with all of this. The QME says that the evaluation of the worker can be done effectively and safely this way. So, is that going to work? Well, most of the time, no. I mean, most of the time it's impractical or impossible to do this, and it's going to have to be continued. I just wonder what's going to happen. You can replace a panel if it's not timely scheduled under the regulations, but the DWC says not so much, not in this environment. We're going to have to, these emergency measures are going to be considered when we consider allowing a replacement panel. So, I mean, we're going to have to just wait and see what happens. Finally, I think the last procedural issue was the time limits for utilization review. There's this case bottom, which says that you have to, if you're going to, every time there's an RFA, you review by UR, right? And what happens if UR is late? Well, that's the only condition under which the judge gets to take jurisdiction away from the UR process, and you go to court and you go to QMEs and you never ever get it resolved, which was the old system before mandatory UR. The problem is that when UR decides to deny mostly or delay or modify a request for care, they have to communicate by telephone, fax, or email within 24 hours, but then there must be written communication, read a letter within 2 business days. Now, all the claims adjusters are at home. They do not have their systems which automatically send out to their, they can't lick all the envelopes and the stamps. It's not possible to comply. So what is the horror? Well, the horror is that all these requests for care are going to now be in the hands of the WCAB, which isn't operating anyway. It's a problem. It's a problem. I mean, without some kind of change in the law, regulation, or determination, a lot of UR is going to be untimely. And that's going to mean that it doesn't go to IMR, it goes to the judge. And the judge, of course, can't hear an expedited hearing. And then, of course, you need medical evidence to discuss it. It's like before the bad old days before, well, from my perspective, the bad old days before mandatory UR. I don't know what we're going to do about this. I anticipate it's going to be a real problem. What are some other states doing? Well, I think this has to do with, we're getting now into the issue of compensability. A letter was written by the applicant's attorneys, I think this is on the next slide, asking for a presumption, but the Alaska legislature passed a bill creating a conclusive presumption that COVID-19 is an occupational disease for first responders and healthcare providers. Reasonable, right? New York, where this epicenter of what's going on with Corona in California, I mean, and the whole country, created a presumption for essential workers, which is food service, retail, education. California, they currently has no presumption for essential workers. But they want one. The labor unions, they want one. They want a presumption that essential workers, which is all workers in California, anyone not staying at home to work or not working at all essential workers have a presumption that if they get the coronavirus, it's conclusively presumed to be work-related. So that's what they want.
What do you think the chances are that's going to pass? I mean, with employment law in California, we are almost always, among any state, the most employee-friendly covered state. So if you have New York and Alaska doing this, what do you think California will do?
I think it's going to pass. I think what's going to happen, well, let me tell you some more, because I want to proviso with that. The day of the executive order per WorkComp Central, the Labor Federation sent a letter to the governor and said, we would like this presumption. We would also like an emergency presumption, conclusive presumption, okay? Not rebuttable presumption, right, covering instances of post-traumatic stress disorder for frontline workers who are affected by the coronavirus. Now, whoa, yeah. Dad, wow. Right? I mean, that's a big deal. And the cause we contacted about drafting an executive order. So the question isn't whether it's going to pass. The question is whether there's going to be an executive order, there's going to be an emergency reg, whether there's going to be legislation. There was a presumption for hospital workers that have been proposed prior to the outbreak. They've been proposing that for many years and been rejected. You know, they wanted it along the same lines as firefighters or cops. The answer is, I think it'll happen. I mean, when you think about it, the basic rule is that non-occupational diseases like colds and flus are non-compensable unless the worker is subjected to a greater risk than the general public. When the general public is staying home, then isn't every essential worker facing a greater risk than the general public?
I would think by definition, yes.
Yes, but in time, maybe people won't be staying home. Maybe it won't be a greater risk. And so that may be a fluid thing depending on the facts of the case and the time when it happens. But they want a presumption. And so I think, I don't know what's going to happen, but I would say that if it does happen, I think there's a question as to whether it'll be a rebuttable presumption or conclusive, and whether or not it applies to psychological impact of this as well as, because look, you don't need to have the coronavirus to have a psychological problem with what's going on. So how far will it go and in what form will it take? We don't know yet, but it's out there, ladies and gentlemen. And that's why I think that my original prediction that it wouldn't be that many claims and they wouldn't be that much of an impact in terms of liability was totally wrong. Because I think there's going to be a lot of cases, and I think that there's going to be a lot of different theories under which it's going to operate. The last time that we were here, I talked about the two exceptions for the general rule of non-compensability. The first is an increased risk compared to that of the general public. And the second is that the immediate cause of the injury is an intervening human agency or instrumentality of the employment we talked about. In the second case, someone being asked to get vaccinated, for example, by their employer. I cannot, I can't even keep my clock down on this one, although I'm doing a lot better. But I can't talk to you about all the different aspects of the compensability of COVID-19 here, and that's why I've set up, like I said, a seminar every noon every Thursday going forward indefinitely to keep you up to date and to break through. But just to run through the issues relatively quickly, I thought this was the only time that this has ever happened before was in 1920, and that was a Spanish flu outbreak of 1918. Workers' comp was 1.5 years old when this happened, and we found 2 cases. And in both cases, the California Supreme Court, which, by the way, there wasn't courts of appeals by then, everything just went straight to the Supreme Court because it's so small. A hospital steward's death from the Spanish flu was compensable when the chance of exposure was 5 to 8 times of the general public. And the same thing was concluded in this other one, where there's a safety engineer who just his work environment is 5 to 8 times. So he was exceptionally exposed, and that was both found to be work related. We have a lot of cases like that that we talked about last time in some depth, applying this standard about greater risk than the general public. Anytime an employee has a special exposure, because of their workplace, we don't have many cases on it. We have like a guy traveling to the valley and getting valley fever, stuff like that. But this situation, it's wide open. We're going to see all kinds of theories, I think, about why people say that any essential worker, and even maybe not an essential worker, just a worker at home. I got it from my husband, but I wouldn't have been at home with my husband if I didn't have to go home, because it put me at a greater risk, even being out of the workplace. You could see any theory being put forth by applicants. So it's going to really be the Wild West in terms of the allegations about how it's going. And the second thing I think it's important to understand that that coronavirus doesn't exist in a vacuum. So what if you have a work-related heart problem and you get coronavirus and it gets worse? Well, it's work-related. That worsening is work-related, although it may be subject to apportionment if the coronavirus is in and of itself non-industrial. The care and any aggravation of need for time off work, this could all be work-related. Or you can have a non-industrial condition which gets lit up, made worse, or actually becomes symptomatic or manifests as a result of the coronavirus. That too would be claimed as work-related. If you have coronavirus and you get dizzy and you fall down the stairs, or it could be all kinds of compensable consequences. Anything causally linked to the coronavirus would be sufficient might be sufficient, under the compensable sequelae cases that we have in workers' comp. Like I said, I'm just listing them more than anything, but you can see issues popping up all over the pop, 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 pop. Every case is going to be different. Supposedly, like I said, and this might be application number 2, a condition of the workplace is an instrumentality of it. Like if you have an industrial heart condition, it gets worse. Hypertension, it gets worse. And it's, there's a difference between a temporary exacerbation of a problem, which gets a little worse and you go back to where you were before. And that's, you don't get any workers' comp for that. But if you get permanently aggravated, that's different. And that's an issue of medical legal fact. But of course, you can't figure that out because you can't get to a QME. But even if you could, you wouldn't get to the trial. So what difference does it make? What about stay-at-home orders? All kinds of things apply here. Now, is the home, when you're working at home, a second workplace? The answer is yes. The answer is yes, it is a second. So if I'm walking around the office and I trip on the rug and I injure myself, is that a work-related injury? Yes, because of the personal comfort doctrine. Doing my nails, anything you do at work basically is work-related as long as it's on-site at work and it's not so personal as to take you outside the realm of your job functions. So,
are injuries on a mandated lunch break? Somebody is on their 30-minute lunch break and they have an injury, is that compensable?
Is it compensated or uncompensated? Is it on-site or off-site? There's a whole section of Sullivan and Comp on this issue.
Okay.
Yeah, it's a complicated issue. And so all those issues would apply if you're working from home.
So
on my lunch break at home, but I'm actually on, does home consider a work-related premise? Because of the premises line rule. What about your garage? Because we have the parking lot cases. So it's just a whole ton of, like I said, all I can really do is here is list the issues.
right. Well,
But they're going to be coming up and we'll be discussed in depth in further future webinars.
well, my thought was, and I'm going to really briefly touch on it later, but one of the keys of at-home work and this impact um, for employers is to be tracking time appropriately when people are on the clock, when they've left for their lunch break, which may make a difference in your world as well
Mm-hmm.
in determining whether they tripped over the rug when they're going to go get their sandwich for lunch,
Mm-hmm.
as opposed they tripped over the rug while they're doing actual work at home.
Mm-hmm.
And I've told all of my clients, you have to find some system that is accurately measuring time, people when they clock in, when they clock out, when they're on their breaks, when they're on the meal or rest breaks.
The wage and hour
for
stuff
wage and hour
is,
issues, but
yeah.
perhaps also for here,
Mm.
for defending on workers' comp claims.
Maybe.
Yep.
We'll talk about it in depth at a future webinar about the scope of home as a second job site. There's also the claims of psychological injuries. Like I said, like, okay, I'm psychologically injured because I wasn't allowed to be at work and I'm all alone and I'm lonely. Is that valid? And if that's true, is that a personnel action such that it would be defensible under 32A.3? And again, I mean, all kinds of there's a psychological injury as a result of having the coronavirus, but is the PD go away because it's the psychological injury coming from an underlying physical or problem? Or does coronavirus count as an underlying physical problem? That's another issue, right? I could go on and on. And you're like, so I'm noticing. And then, of course,
But you'll have one slide left, so you won't.
Until you have one slide. But I'm almost done. I'm almost done. I think this is like my last
This
slide.
is your last slide.
And then it's going to be your fault if we're late.
Yep.
But no, actually, we're doing pretty good. We could be doing worse, in other words. You said 35 minutes for your slides, but you lied because you have like.
I can't stop talking.
Yeah,
I haven't stopped talking this whole time.
I knew.
So.
As soon as you said that, I was like, he's a liar and he's self-deceptive.
I can't help it. That's why we're a pair, because we both can't stop talking.
Yeah. We're getting through a lot, but man, there's just a lot here, folks, which is why we're going to do it once a week for a few weeks and just really work through it.
But to be fair, everybody can thank me because you originally wanted this to be a 3 to 4 hour seminar, and I got you to cut it down to 2.
I think
so. You're welcome, everybody.
You're taking undue credit, and by implication, committing actionable slander against me.
Fortunately, I have witnesses.
Who work for me.
Good point. Okay.
So I'm not saying,
I might lose
Mike,
that one.
I don't say your job's on the line, Mike. I'm just saying that, I want a fair and honest interpretation of the events.
Oh, he just winked at me. We're good.
Anyway, okay. So duty to provide a claim form. That's a hot topic too, because, I've heard it said, hey, if someone has the disease, then give them a claim form. If they appear to be essential, then give them the claim form. But there's going to be, this is a question. I mean, under Honeywell, you don't have to know about an injury. Excuse me. You don't have to be reasonably certain about someone's having an injury that's work related. You have to know it. And it's a really high standard on Honeywell. We're going to talk about it in our next seminar, but yeah, I can see it makes sense. If someone comes down with the virus and it's obviously from work, then even if it didn't meet the standard of Honeywell, you might provide a claim form. But are you going to give a claim form to every single person that gets the virus that works for you automatically every time? Well, that's an issue.
If there's a presumption, if that bill passes and there's a presumption, don't you have to?
I don't know. I don't think so. It depends on how Honeywell would apply. So that's something that's going to have to be broken down deeply in one of our future seminars as well, because generally you don't want to give, if you're an employer, you don't want to give claim forms, because what are they going to do? They're going to file it because they don't know they don't know what they're doing. You give them a piece of paper, they fill it out, right? So it's a really subtle, difficult question as to where that line should be drawn, and it's highly fact dependent. But anyway, I'm going to shut up for a while, let you keep us up to date on the FFCRA, which everybody knows is the Family First Corona Response Act. Everybody knows that.
Everybody knows that, and if you don't,
if you don't, well then.
Well, if you listen to our chapter 1, you knew what it meant. So, and this is, I'm bringing this back. I know we talked about it to some degree for the first chapter of our COVID-19 seminars. When we talked about it, it was the day that it was passed by the Senate and signed by the president, and we could only read it as it was literally and just assume of how it was going to be applied. Now, that's turned out to be quite different, and there's a lot of really significant changes that came out with new regulations and clarifications last week. So I'm compelled to go through this again in detail because this is the primary question I get from clients about how the Families First Coronavirus Response Act interplays with everything else we have to deal with in California. So it's important we get our hands around FFCRA first. So again, it was signed March 18th into law. It has many different aspects to it, but the key two aspects that we're going to talk about that impact employers is the Emergency Paid Sick Leave Act, the EPSLA, and the Emergency Family and Medical Leave Expansion Act, EFMLEA.
So more sick leave and more FMLA.
And a new category under FMLA. And there was a time when I really thought workers' comp had cornered the market on acronyms and all the letters floating everywhere. And
You're catching up.
Thanks to COVID-19, we are catching up.
Yeah.
We have FFCRA, EFMLEA, EPSLA, FMLA, CFRA, and LMNOP. So so you're welcome, everybody. We're going to try and get through all of that.
Okay.
So it was effective as of April 1st, 2020, expires December 31st, 2020, and it's enforced by the WHD. Now, who needs to worry about this?
Do you want this thing or should
I'll take it.
Okay. I just gave him the clicker so he could click through his.
He reluctantly
slides.
gave me control.
Yeah, I gave up control, so that was a big moment for me. I'm going to talk about it later with my psychologist.
Yep.
We're going to celebrate this.
So
maybe have a little cupcake or
okay.
something.
Tequila. So for employers who need to deal with it, it's private sector employers with fewer than 500 employees. And yes, I get the question a lot. Nonprofits are included. If you're public agency, doesn't matter the number of employees you have. It's regardless of number. So
only small companies.
It's small companies, 500 or less.
That was the ones that got the funding for the loans from the federal government. It's under 500 employees.
Which is the category for the CARES Act as well.
CARES Act, yeah.
Yep.
Yeah, that's what I meant, what you said.
That thing.
Yeah, that's the thing that you said. Yeah.
So those are the employers that have to worry about this. Now, that's not to say that these employers don't need to worry about every other type of leave, FMLA and CFRA, the other school activities leave, which I'll get into briefly later. So you're not necessarily off the hook, but this is what applies for FFCRA. These are the qualifying reasons under the entire act. Oh, thanks. That's why he has control, because he knows when to click the cursor. The qualifying reasons are an employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19.
Which is everybody.
Well, no.
In California.
Well, this is where the clarification came into.
Okay.
Under this first category, we had thought, well, that's everybody that has to go home and be home and they can't work because businesses are shutting down.
Okay.
But the clarification last week is, and we're giving up a slide for later, but it's important now anyway. No, that's not the case. The way we apply this is if you would have work otherwise, it's a causation factor. If a company is completely shut down, you wouldn't have work. Either way, you can't be at the office. You can't be there because there's no work to be had. If you're furloughed, there's no work for you to be had. So you don't qualify under this.
Oh, you don't?
If you're laid off, you do not qualify under this.
But you're still under a state order to isolate by the governor.
You are, but if you weren't under that isolation order, there'd be no work for you because the company's shut down.
Wow.
So that's why we're wrapping our head around this, because everybody thought, okay, we're shutting our doors. Everybody has to be paid under the FFCRA.
That's a big change, man.
It's a huge change.
So if you're laid off or fired or whatever,
or just furloughed for 2 weeks,
you're not getting your extra sick days and your extra FMLA.
Not under this act anyway.
Not under this act.
Not under
California's
this act.
different.
Yep. Not under this act. So that's the first one. That was the big change in the regulations, or clarification as they put it in the regulations.
It doesn't seem like that's what it says. It
Yep.
says you're under an order by federal, state, or local court.
Yeah.
That doesn't seem that regulation makes much sense to me, given the little language of the statute.
Agreed.
But that's what it says.
Yep. The second one is, it's been advised by a healthcare provider to self-quarantine. That doesn't necessarily need a medical certification. Is experiencing COVID-19 symptoms and is seeking a medical diagnosis.
But you need all three.
No, these are different. These are different categories.
Okay, so you can get it if you meet any of these three.
Yep, there's six. There's
Oh,
six.
oh, well, that's not so bad then.
There's six. So
that's not so bad. You can get it. We can get one of the six, right?
Yeah, so one of these six you have to qualify under, and I'll break down why it makes a difference which one, because it depends on which kind of pay you have to make. It's either 100% or 2/3 pay, and we'll get into that.
Okay.
So the other 4, 5, and 6 is caring for an individual who is subject to a federal, state, or local quarantine order related to COVID-19, or has been advised by a healthcare provider to self-quarantine. And this fifth one is going to come up in both EPSLA and EFMLEA, which is caring for his or her child whose school or place of care is closed due to COVID-19 related reasons. That it happens everywhere. And the last one is experiencing or substantially similar conditions specified by the U.S. Department of Health and Human Services, which is their catch-all. Anything else that might come up? Okay.
Well, that's a lot. So it seems like most people get in here somehow.
You would think so, but it's hard to get into that unless you are caring for somebody who actually has COVID-19 symptoms. You yourself have them, or you're caring for a child.
A lot of people are caring for kids.
A lot of people are caring for kids, but that doesn't necessarily mean they can't telework.
Oh, yeah.
Right?
Well, it's not just try doing it, but yeah.
Yeah, so, exactly. So you have to be unable to work in order to qualify for any of these, either work or telework.
Okay.
So as I had mentioned before, they specified it does not mean for the people that doesn't qualify for people who are under isolation order but wouldn't have work otherwise. So the laid off person, the furloughed person, the entire company is shut down, result is not a qualifying reason for FFCRA. Okay. So there's an exception that has been carved out that was also incredibly vague of how you qualify for this exception. Generally,
exception to what?
Exception to having to give leave under the FFCRA. It's a small business exception. So businesses with fewer.
So even if you meet one of the 6 criterion, and if you meet this exception, the small business exception, you don't get the extra stuff.
Correct.
Okay, got it.
Correct. And you may not have to give these employees leave if they apply for the leave. So it's 50 or fewer employees classifies you under this exception. The employee's leave to care for his or her child whose school or place of business is closed, but requirements of the FFCRA jeopardize business viability. So everybody, a lot of small businesses were saying, hey, I know I get a potential tax credit for paying this, but I can't front this money. What do I do? Well, they say you need to apply to qualify. But the reality was they didn't have the resources to deal with these type of patients. So what we've learned now is there is no application process. So this is determined unilaterally by the employer.
Okay.
The employer with 50 or fewer employees determines whether they fall under this exception. And these are the 3 categories it can fall under. The leave would result in expense and financial obligation exceeding available business revenues and cause the small business to cease operating.
Well, this is only the 50 or less employees and they're going home to take care of kids.
So this is,
and if this is like when it becomes just not feasible as a business, the third prong, which is it's not feasible as a small business to do this.
Correct.
I get it. And these are 3 different things that the employer can determine that would meet the third prong.
Yep, exactly. You got it. Yeah.
Thank you.
So employees, the second one is employees' absence would entail a substantial risk to the financial health or operation capabilities. That's saying you can't let the employee go. You can't let them go because it's going to impact the company. And that you have insufficient employees able, and this is an or qualification. This is one of the 3. Insufficient employees able, willing, and qualified at time and place needed to perform labor or services. So if you find that one of these qualifies, you might fall under the small business exemption. The key here is going to be properly documenting it making sure when so you get to determine this unilaterally. Make sure you do the work ahead of time before you do it, because you may be very well called on it when you're denying leave for these reasons. So yes, it's out there for you, but do so with caution and with documentation.
Yeesh.
Yep.
You're gonna get sued.
Well, it's the reality. There are so many different types of laws. There are so many different requirements now that we are grappling with, that it's inevitable that new types of causes of action are going to come out there. Plaintiffs' attorneys, sorry if you're out there, are chomping at the bit on a lot of these types of cases, and employers will make errors. I expect employers will be forgiven to a degree for making these errors, because everybody knows what this is like. Everybody is in the same boat. But there's exposure here, and we have to, and this is one of the things we have to understand. Mike and I, and Mike doing these other seminars, we're going to try and keep you up to date to what the world looks like now. This is the way the world looks like today. But you can't then tune out as employers. Employers have to be, in this environment, vigilant about the changes on a regular basis. There's just no saying, well, I heard that 2 weeks ago, so it must be gospel. What we knew 2 weeks ago, disregard it.
It's like the HR version of brushing after every meal.
It is if everybody did this, I would be happy. So yes,
it would have good,
brushing and keeping up on your employment law. Absolutely.
Yeah. The price of healthy gums is eternal vigilance.
It is.
Yeah.
So I mean, this is how we see this today. It's important to stay tuned as the days go on, because it's going to continue to change and evolve. There's a few other exceptions to the FFCRA, and we've heard about this already. It's healthcare providers, for obvious reasons, and emergency responders. Those are the two that are areas of occupations that are exempt from FFCRA. So the first category of FFCRA is the Emergency Paid Sick Leave Act. And there's different requirements for both of these. So and that's why this is in a PowerPoint for you to go back to and review. So the benefits of the EPSLA are there's 6 qualifying related reasons, which I went through before. You continue the health care during this period of time. So your health care continues, and they're entitled to paid sick leave for over a 2-week period of time. They were saying previously 10 days, but they've updated it to say 2 weeks, because it affected people differently depending on whether they're part-time or full-time, and it became a mess in administering it between the EFMLEA and paid sick leave. So now it's a 2-week period of time up to a maximum of 80 hours. And the part-time employees, it's hours based on their average schedule over a week.
So you get 2 weeks of pay if you hit one of those 6.
If you hit one of the 6.
Then you get the 2 weeks of pay, but you don't get overtime. You don't get excessive pay from your part-time.
Correct. That's absolutely right. And you get your healthcare coverage.
Yep. Okay.
So it's all employees who work for covered employees are eligible. The covered employees, so they're under the EFMLEA, which we will talk about later. There's a qualification that it has to be for at least 30 days.
Mm-hmm.
This is for everybody. There's no qualification. You don't have to be there. You can be there for 1 day, and you qualify under the EPSLA. And the covered employees are, again, private sector, under 500 employees, and public sector, all public sector. There are some federal exceptions. Not really going to go into that here. They're very few and far between. But assume if public sector, it doesn't matter how many employees you have, this applies. So
that's the sick leave.
We're just talking about the 2-week sick leave.
Okay.
2-week sick leave. So here are the 6 reasons again, and I numbered them. The first are 1 through 3. I won't belabor that, but all 6 are under the EPSLA. I'm sorry, yes, EPSLA. I'm getting my acronyms mixed up too. So under the paid sick leave, all 6 are the qualifying reasons. Now,
and you could have just one of them. Why are you showing them again?
What's that?
Why are you showing them again?
Because Well, FFCRA has them all together. EPSLA has 6. EFMLEA has 1 of those, which is number 5. So that's why I showed all 6 at the beginning. They're all under the FFCRA.
Oh, okay. Those are the 6 reasons that apply to both the sick leave and the FMLA.
Yep.
This is just for the sick leave.
This is only sick leave.
Okay.
There is only 1 qualifying reason under the FMLA expansion.
Okay, so it's the same 6 you showed us before, though.
Yep.
Okay.
Okay. Yep.
Yeah.
There we go.
Got a little crazy.
Got a little ahead of myself. Okay. So again, the duration is a 2-week period. And the clarification that we got last week that we kept being asked is, well, when if they want to take, when if they don't want to take the 2 weeks all at once? Can they take it by a day, 2 days, 3 days? And the answer is yes. They can take it in as many increments as they like, up to those 2 weeks and 80 hours. It is at their election. So, well, they qualify, so I'm going to start those 2 weeks running. The employer doesn't get to elect that. The employee gets to elect that when they want to during this 1-year period of time. And again, it doesn't spill over into 2021.
Is it overlap? Is it additive or to regular sick leave, or am I getting ahead of you?
Sure. No. So
it is on top of regular sick leave?
It is in addition. They made very clear.
In addition.
Everything under the FFCRA, the paid sick leave and the expansion under the FMLA is in addition to, not to be supplemented or go concurrent with existing rights under either state or federal law.
How's that going to work on salaried employees with unlimited PTO?
It's complicated.
Great.
Yeah.
Didn't expect that.
Yeah, it's complicated. So these are, so we can't say, well, your sick leave is running, so your FFCRA is running at the same time. You cannot do that. This is in addition, and they get to choose this first. We don't get to say, well, use your vacation and your accrued sick leave first.
Well, at least we know now. At least we know it's not. It's an add-on. It's not. It doesn't. You write this plus regular sick leave.
Correct.
Yeah.
Yep. Okay. So this is why the 3 reasons matter.
There 6 reasons.
The first, well, okay, total 6 reasons. The first 3 reasons are different than the last 3.
Right, because it's how much you get.
It's how much you pay. So for the first 3, they get 100% pay during that 2-week period of time. And those are, again, the under orders for isolation, quarantine, has been advised by a healthcare provider to quarantine and is experiencing themselves COVID-19 symptoms. There is a cap, though, on their pay as $511 a day or $5,110 in total. So there are caps.
Ugh, good Lord. So I don't want to slow you down. But
no, go for it.
Let's say I got, go back, will you? Oh, this is where you're at.
That's it.
You did go back. So let's say I got a head of IT, okay? Director of IT. And they have, let's see, they're getting symptoms and they want a medical diagnosis. They're making $400,000 a year. Not that people make that here, but let's say it's a different company.
Yep. This is a complete hypothetical, people. IT don't get excited.
And he's on unlimited PTO. But it's only $500. How does that work?
So if he elects to take, I want my EPLSA, to which I am titled, because we are under 500 employees. I have a symptom.
We agree. You're entitled.
We have 3. So I'm taking 2 weeks at this cap. Would he want to? Probably not.
Yeah. So the white collars are not going to like this if they're unlimited.
Well, they just won't take it.
They just won't take it.
They'll take the more benefit, the greater benefit of their full pay.
Right. See that a lot of workers comp too. Not many white collar claims unless they're out. They're done with their career.
And it also matters when we're talking about unlimited PTO is how the unlimited PTO policy is drafted. Many unlimited PTO policies carve out. This isn't for extended periods of time of sick. This is for, if it's 3 days, 4 days. So if you're extended period of time of sick, this is not meant to be for 12 weeks of FMLA leave. Okay. This is, so if it really matters how your sick leave policies have been drafted, and if appropriate, this probably wouldn't be under your unlimited PTO. in the first place. So,
$511 per day, huh?
so that's the max for those two weeks. Now, if you're in the 4 through 6 category,
Taking care of your kid.
taking care of your kid is number 5, and that's important because it overlaps with the FMLEA. But number 4, caring for an individual who's subject to quarantine related to COVID-19, or is experiencing any other substantially similar condition, which is the catch-all we talked about. In these 3, you get 2/3 pay.
But it's capped at $200 a day, so it's less than 2/3.
Yep. Capped at $200 a day and maximum of $2,000 in total. And this is just, remember, this is just for the 2 weeks. This is a 2-week period. Now, why is, so what we've learned though, is that the overlap between reason 5 being in the paid sick leave and also being in the Emergency Family Medical Leave Act was there, it's there on purpose. They're meant to work in tandem. So
the person taking care of a child is not going to get as much sick leave, but you're going to tell us about some FMLA stuff.
Yeah, so the person taking care of the child is going to get 2/3 of their pay for 2 weeks under the Paid Sick Leave Act, right? Because they're category 5. Now, they also are qualified under the EFMLEA, which is the expansion of the FMLA.
Now, I don't know that much about FMLA, but I got the idea that you can take time off of work without getting paid for up to 12 weeks. I see this a lot with women that have their babies.
Sure.
Right. And they file for disability during that time. But
well, there's so FMLA, the Family Medical Leave Act, corresponds to what we also have in California, which is the California Family Rights Act, CFRA. Typically, they both work the same. They have the same requirements. They have the same period of time you have to work, same hours you have to work in order to qualify, same 12 weeks of unpaid leave. There are some exceptions, one of them being the one you're talking about, which is disability by pregnancy. That is a qualifying reason under FMLA, but specifically excluded under the CFRA, which means FMLA can run for somebody who's taking time off disabled by pregnancy for 12 weeks. But because CFRA hasn't run, it's not a qualifying reason, they get another 12 weeks to bond with their child.
Unpaid.
It's all unpaid.
Okay, so they can go 6 months.
It actually ends up being 7 because you get 4 months under pregnancy disability leave. So a person who's actually disabled by pregnancy can have up to 7 months of unpaid leave.
Right, but they get paid by the state of California for their.
They have benefits under UI, under paid family leave, et cetera.
Which works if you're blue collar, but not if you're white. White collar people make too much money.
For paid family leave, the benefits they're typically pretty low.
Yeah,
for sure. So under EFMLA, the benefits are it's only for number 5 to care for son or daughter whose school has been or place of care is closed. You get 12 work weeks of job protected leave with continuation of health benefits, and the initial 2 weeks are unpaid. The remaining 10 weeks are at 2/3 pay. Now it says the initial 2 weeks
pay, 10 weeks.
10 weeks.
Wow.
2/3 pay. This is the qualification for number 5.
Because normally FMLA is no pay.
Correct.
But now you're getting paid if it's coronavirus. And the 2 weeks, of course, it goes into the sick leave stuff.
There you go.
Yeah.
So the 2 weeks, and this is done well, we didn't know before, but now we know it's done on purpose. So a person who is has to take care of their child because their school or place of care has been closed can get the first 2 weeks of this 12-week period paid through paid sick leave, and then the remaining 10 through the EFMLA. And either way, they get 12 weeks of protected leave during that whole time.
Well, that's going to happen a lot because there's a lot of kids home from school.
Yep. And I mean, one of the reasons has to also be, hey, I can't telework. I cannot telework. I can't work remotely. So it's not just I'm teleworking, but I also have to care for kids. I'm on EFMLEA. They have to say I cannot work, or I can't work intermittently. I can only work 3 hours a day or 4 hours a day teleworking. And then we have to calculate what part of that goes into the EFMLEA.
A lot of people that's an issue of fact, is what lawyers call issues of fact, is a lot of people right now establishing that they can they're doing it. They're home with the kids and they're working. So
Right.
they're actually hurting themselves for a later argument that I can't do it with the kids around. And I would now like 3 months at 2/3 pay. Is there a cap of $200 on the FMLA stuff?
It, it is, well, it's a longer period of time, so the cap is bigger. And I'll get to the cap in a
Well,
second.
yeah, but the daily rate is
Right.
200.
Yep.
Well, boy, the kids are
cap,
all going to be home from school the rest of the school year, so this is a big deal.
this is going to be one of the ones to track. And this is the advice I'm giving generally for all of this, because it can be a mess. And it is important to start now, if you haven't already had a practice of doing this, tracking what leave people are on. Are they on paid sick leave? Are they on paid sick leave through the EPSLA? Are they on regular FMLA or CIFRA? So, yeah, and this is key. And my HR people are trained in handling these leaves. It's not new that we have a ton of different leave opportunities in California.
Yeah.
There are too many to list here. So this is just another one to track, and how you track it's important. And not only is it important, we'll talk later, it's important if you want to get tax credit, because the one benefit here is that if you pay out on either of these leaves under the FFCRA, you get 100% tax credit from the government, but only under certain circumstances, which I'll talk about in a second.
Because you don't have your worker.
Yeah, well, it's the documentation. It's all about the documentation.
If you don't have your workers, my point. I mean, it's one thing to get full tax credit for the payment you made to the worker, but the damage to the business usually is the worker not being present.
True.
And no one who knows how to do that is there.
Yep.
So your accounting department's not there. Yep. It's great that you get paid back for your $200 a day, but unfortunately, you didn't get $1 million in receivables during that time period, because you're training people who, by the way, you can't keep long because these people are coming back.
And there comes the CARES Act.
And then comes the CARES Act.
Yep.
Give the small businesses a bunch of money to make them not die during this period.
Yep.
CARES Act only lasts 2 months though.
It's true. Not enough. Well, for now, it lasts for 2 months. For now. So eligible employees, a little bit different than paid sick leave. They do have to be there for at least 30 calendar days, where they don't need to be there for 30 days under the Paid Sick Leave Act.
Oh, you have to have worked there at least 30 days.
At least 30 days. But
Yeah.
that's going to be an easy mark for most.
Right.
But what they're trying to avoid is a person who just started working the day before, and now I'm gone for 12 weeks on paid 2/3 leave. That's what they're trying to avoid.
Yeah.
Qualifying reason, again, only one under the qualifying reason. We've already talked about that.
That's important though, because there's not these 6 qualified for the FMLA. It's specifically targeted for people taking care of kids.
That's the only 12-week reason for going. That's it. Just to care for your kids. So paid versus unpaid. The initial, like we talked about for FMLEA, the Family Medical Leave Act, the first 2 weeks are unpaid. The employee, in addition to what we talked about under the Paid Sick Leave Act, can use anything else during those 2 weeks. So they don't have to use emergency paid sick leave, and you can't require them to do it. They can use whatever they want during those 2 weeks.
Well, obviously, these things dovetail.
And they dovetail on purpose. But arguably, somebody can say, "Hey, I'm good right now. This just started happening. I want to save my paid sick leave for July or August, when I might really be hurting.
I plan on calling in sick when I go to Hawaii."
Exactly. Or I love your cynicism, and I share it. Salty defense attorneys at our best. But yeah, that's so they have the whole year to do it, and you might find a lot of people.
Well, they might want to do it because they're making more money on sick leave than they are on this. There's caps on how much they can make with the sick leave here of 500 and what? 500 something.
511.
Yeah. Whereas if they're making $1,000 a day in their regular job and they plan on doing this anyway, they might as well get 2 weeks of their regular pay, not a regular sick leave.
And we'll probably have a lot, with the hope that things start, being alleviated in the next months to come. We're probably going to have a rush to use this in November, December, because it ends at the end of December, as of now anyway. So you might get a lot of employees who have already come back to work that might be using this later on because they haven't accrued it later, and it's a use it or lose it.
But here's the thing, I think the workers are in trouble because it's like all my workers at the firm, they've all been working from home for 2 weeks. And a lot of them have kids, and none of them have invoked this because they didn't know about it. But now if they invoke it, they say, "Oh, I can't do it." So you've been doing it for 2 weeks.
Well,
how's that going to work?
No, they've all known about it.
Oh,
because I notified them.
Oh, you did?
Yeah. That's why you got me.
They just don't want to do it. They want to work. Probably because they make more money working than they do doing this.
Well, yeah, and I think most people do want to work. I mean, people are stuck at home. Most people do want to, work if they can, and the less time they have to deal with their spouse. So, because everybody's stuck together.
Well, $200 a day is not much. It's like 32. It's like equivalent of like 37,000 a year.
Yep.
So remember, if you're a $50,000 a year employee, you're going to want to try and work at home.
Remember, they're still getting their regular rate of pay. It's still their regular rate of pay, whatever they would get during that period of time. It's just capped at a certain amount.
Well,
so
effectively then.
Yep. So how you calculate it is regular rate of pay.
Do they take out Medicare and taxes, like payroll taxes?
No.
They don't take out payroll taxes at all in this.
Not when you're calculating the regular rate of pay.
Far out.
Yeah.
But they do when on regular sick and vacation time.
Yeah. But when you're calculating what the regular rate of pay, you don't take that into consideration.
Oh.
So this is the biggie here, actually. It's the cap. If I didn't mention it already, because it's 12 weeks, the cap is $10,000. And it's for that 10-week period of time is $10,000 cap.
Well, it makes sense.
Yep. So the interaction of FMLA and CFRA, and this is important to keep in mind because we have these two laws. One is federal, one is state. And typically it's pretty easy to handle because they have the same qualifications, the same types of leave. Serious injury, serious health condition is the main one. And the big question is, well, is COVID-19 a serious health condition for which FMLA would apply? Perhaps, and it depends. It depends on how it's impacting that particular individual. So a person with COVID-19, if they're experiencing severe symptoms, might have a serious health condition where the 12 weeks of FMLA should be running. And if that's the case, you need to be designating it as FMLA leave. You can't retroactively 12 weeks later say, oh, you know what? I think that should have been FMLA. We're going to make that FMLA leave. You can't do that.
So is this overlapping regular FMLA or is FMLA on top of this?
FMLA and CFRA?
No, not FMLA and CFRA. I mean, the FMLA for the coronavirus and regular FMLA. Can you have both or do they overlap?
Well, now we know because we used to think, well, I could imagine a world where the federal government gives another 12 weeks. They haven't done that. They've made it clear that this is just EFMLEA is just another qualifying reason for FMLA.
With different terms.
It's regular FMLA.
Okay.
There's differences. One of them being you don't have to work there for 12 months. You only have to work there for 30 days.
So the sick leave is additive. The FMLA is overlapping.
Well, EFMLA is
overlapping FMLA.
Correct. I guess the better way of saying it is it's a new reason for FMLA. It's a new qualifying reason.
The point is you don't have to do 24 instead of 12.
You just do 12.
Right, but the sick leave is an extra 2 weeks.
Correct.
Yeah, okay, you got it.
Well, and you bring up a good point. So that's FMLA, but CFRA is different. California Family Rights Act has not included this reason to care for your children as a qualifying reason, which means, similar to what I was talking about with disability by pregnancy, now you might have another 12 weeks under CFRA for qualifying. So a person can take FMLA leave for 12 weeks, and under the new EFMLA law to care for your child whose school has been closed. And because CFRA hasn't run, they're entitled to another 12 weeks.
But they don't get paid under CFRA.
CFRA is an unpaid leave.
Okay.
Correct. But that's why it's important to calculate what leave somebody is on. If somebody is on leave because of COVID-19, and it might be a serious health condition, if it's a serious health condition, both FMLA and CFRA run concurrently, and that 12 weeks is gone.
Oh, really?
Yes.
Okay.
So they're concurrent in that case. The analysis is different only when there is not a a qualifying reason under one or the other, then they might work consecutively.
Hmm.
So
why doesn't the pregnant woman, why does she get 12 plus 12 unpaid?
Specifically because California has excluded disability by pregnancy as a qualifying reason.
Okay, I get it.
And instead, they gave her 4 months under the pregnancy disability leave. So CFRA doesn't run when somebody is disabled by pregnancy.
I got it.
FMLA runs.
Okay.
Yep. And pregnancy disability leave runs at the same time as FMLA.
It's like one of those books. You're like, if you say yes, go to page 4. If you say no, go to
if
page
the
7.
train is.
Yeah. Do you choose to get on the boat or walk down the road?
Right. It's complicated, and that's why I bring it up, because this is not easy stuff. People who've been handling leaves, it's not terribly complicated. It's just important to track it. It's important to document it.
Well, that's always been true of HR realities.
Yep.
The problem with the small businesses, you just don't have the resources to do it. Now, I guess that's why you use, paychecks or ADP.
Or ADP.
Yeah.
They're fantastic.
They are.
Thank you, ADP.
We use them.
They're like, thanks for the pitch, you guys. Okay, so there is, for the people who have been struggling with what this means since March 18th, they have had a temporary non-enforcement period for people who are, messing it up between March 18th and April 17th. So if you haven't figured this out yet, if you haven't been applying it correctly, you have until April 17th to get your ducks in a row. It won't be enforced it's basically a period of forgiveness for that period of time. So that's good news. The bad news is you're going to have to get everything in gear pretty quick. Now,
the merciful.
This is what we just learned from the IRS. Yes, employer, if you're giving this FFCRA leave, the 2 weeks paid sick leave, the 10 weeks of EFMLEA, yes, you will get it 100% reimbursed, but if you want that, you have to document it. And this is the criteria that you have to document when somebody goes. The employee's name, the date or dates the employee is requesting leave, a statement of the COVID-19 related reason the employee can't work or telework, and written support for that reason, and a statement that the employee is unable to work for that reason. So how does that play out? The way it seems to play out is you have a communication with the employee in writing. They tell you what reason of the 6.
Well, who's asked to make the statement? The employer or the employee?
The employee. The employee is making a statement of the reason they cannot, in writing, of which of the 6 applies.
Well, you need a form for this then if you're an employer.
A form would be ideal to check these boxes in order if you're going to want to get paid back for this leave that you're paying out front. And this doesn't come from the Department of Labor, it comes from the IRS. So yeah, we'll give this back to you, but you have to satisfy all 4 of these criteria. So documenting is important. Making sure that these 4 are part of your documentation is key if you want your money back. So we've already talked about FMLA and CFRA. The one I really want people to pay attention to, because it can get really tricky, are your city and county ordinances. Those are constantly changing, and you may be required to do more in your particular city or county than you would have to otherwise. There's no way I can get into all of those. There's just way too many. But the one I do want to highlight is the new LA sick leave ordinance. LA already has a requirement for employers to provide up to 6 days of sick paid leave, which is 3 days more than the California state requirement. 6 days of paid sick leave, and that has been now expanded under this new ordinance.
Is it overlap or additive?
I'll tell you. So the big deal about this one is this is targeting those people who do not have to pay under FFCRA. This is for the employers who have 500 or more employees. So they're targeting those big employers. You might have got out of that with the federal government, but you're not getting out of that here. If you have 500 or more employees, this applies to you. So if you're in that category, you have to be tracking this leave. The employee who is employed from February 3rd to March 4th are covered under this. There is a presumption that an individual is an employee if they're asking for this. What does that mean? If you're saying they're an independent contractor and they say they're an employee, there's a presumption that they're an employee. Now, before I get deeper into this, this is a point I want to bring up. Remember those days, and we talked about this before, where we were worried about AB5. And
the good old days.
The good old days.
We were so cute back then.
Where that was the big issue, and we thought it was, the end of the world, and here we are. It's going to be rearing its ugly head again.
Well, everybody wants to be an employee.
Yep. Exactly. It's going to be rearing its ugly head again now because of all of these new requirements. And we have the California Secretary of Labor telling everybody, hey, go apply to EDD, even if you're an independent contractor, and we'll determine if you're an employee or not. Yeah, this was on a tweet. So there's going to be a rush to the EDD.
Luckily, that has no implications for workers' comp.
Well, lucky.
That was
lucky
you.
Yeah.
That was sarcasm.
Yeah.
Oh, I'm an employee. I'd like to file my CT claim now.
And it's going to hit us. It's going to hit hard. Maybe not in the next month or two, but it's going to be a huge issue as we go down. We're going to have EDD investigating, making determinations. Independent contractors are actually employees, and the impact is going to be real. In this ordinance, it kind of applies to that. It's saying, hey, I don't care if they're independent contractors. If they say they're employee, they're presumed to be employees, and you're going to have a hard time trying to prove otherwise, employer. Exceptions, the same exceptions that apply in FFCRA apply to this sick leave. And let's see, what's the other? We don't need to get into all of this, but I did want to bring up the reasons are the same, except there's one for the sick leave that says those employees that are just 65 or older and have a health condition, those people, just because of their age, can take this leave. Okay, and that's one of the unusual aspects of it. I put the details in here because we have a lot of clients that are in the LA area, and I want you to take a look at it. So make sure that you are complying with this new law, especially if you have 500 or more employees. It's intended to carve out anybody who actually has to pay FFCRA. It runs concurrently, so you have no additional obligation here. If you have 500 or more employees, you have an extra 10 days you have to pay in it, of sick leave. So pay attention to that and make sure that you're complying with it and documenting which leave these people are on. I also put the penalties in here as well.
Well, what if you just forget though?
What if you forget what?
What if you just forget
to pay?
Yeah.
Well, it's no big deal. You can always hire us to defend you. No big deal at all. But yeah, I don't know that's the defense we'll put on, but we'll
reinstatement, back pay, legal equitable relief, attorney's fees. That's the
and that is the biggie.
That's the big. That's what gets you on. That's what gets employers on the discrimination.
That's what drives most employment law cases, is the attorney's fees issue.
Yeah, damn lawyers.
I hate them all.
They're everywhere.
Except for us. So here's I put the leaves here again just to remind you about the main ones. The other one to keep in mind is there's also this school activities leave in California for employers with 25 or more employees. They're entitled to 40 hours unpaid leave.
Is that on top of
on
CIFA?
top of
CIFRA?
On top of CIFRA, on top of FFCRA, because that's on CIFRA. This is not a qualifying reason.
You just get it for any reason? 40 hours?
40 hours. No, school activities leave is for a parent to go to an activity for school, or if there's a closure by state mandate, which is where this applies.
Okay.
So a lot of people.
My kid's going to a play. I get that day off, and it doesn't take off my sick leave. It doesn't take off my FMLA. It doesn't take off anything.
It's your school activities leave. Yep.
Oof. Well, I want FMLA, CIFRA. You could get like 2/3 of the year off if you really manage it correctly. You're not going to get paid for it though.
Some of it.
Unless you're disabled, you can go get an EDD.
Yep.
And they'll determine that you're an employee that's disabled.
And then you'll have a misclassification suit.
Yes.
So,
for your.
So if that's where you're getting your pay, then
psychological condition and your dependency on the medication. Yeah.
So am I running low on time?
Yeah, but you're almost out of slide. Yeah, you're about, you only have like 5 more minutes and you got like
I can do
7
that.
more slides.
I got that. So we talked before about Cal Warren Act. The only reason I want to bring it up again is that there's this new business exception. What Cal Warren Act has done is they've mirrored the federal Warren Act for employer, and federal is 100 more or more employees. California is 75 or more, and they've softened the requirement for a 60-day notice if you're going to do layoffs. The way they've softened it is they've made the requirement the same as federal law for a business circumstance that was not reasonably foreseeable at the time, which is this COVID-19. So if you can fall into this particular category or exception, you might be able to waive the 60-day notice. But you have a lot, it doesn't waive Cal Warren Act all entirely. You have a lot of requirements in order to comply with it. Most of it is about notice, notifying your employees about once you actually know and it's practical to give them notice that you're going to be laying them off. Notice to the EDD and Labor Workforce Development Agency. And I outline the key criteria. We also did an article last week, which we published, that's on both the website, the firm website, and on LinkedIn, if you're interested in it. But these are essentially the criteria for qualifying under the waiver of the 60-day notice. And hopefully we get to a point, and where we've been with a lot of clients, is finding ways not to do layoffs, to do brief furloughs, in order to keep people at work.
Well, that's what the Warren Act is. I mean, that's what the CARE Act is for. You know, I know a dentist who's like, didn't care about the CARE Act. She's like, I can't do my practice. There's no point of keeping these people on the payroll. I'm just shutting down, even though they would have paid her to keep everyone, essentially, to keep everyone on the payroll for 2 months.
And that's where CARES Act actually gives them until June to get those people back on the roster as employees.
Mm-hmm.
So they've anticipated that, and they've given people an opportunity to bring back that workforce that have already laid off people.
But some people won't.
And some people won't.
Well, it doesn't make sense. They're paying them to sit there.
Yep. But one of the things that I want people to understand is the difference between a layoff and a furlough. And people mix them up quite a bit. And it's understandable because the guidance in California is weak. So a layoff is a complete termination of a workforce, meaning at that time, arguably you have to give all of the termination pay, all of the vacation that's accrued, everything needs to be paid out on that day when you lay off people. All of the waiting time penalties apply. When you're furloughing employee, it's just for a period of time. Now, the guidance we have so far is from the DIR, the Department of Industrial Relations, is a letter opinion from, I think, 2003 that says, hey, you can furlough employees, but if you do it for more than a pay period, we're going to assume it's a layoff. It's a presumptive layoff, which is sticky here because this is obviously going to last more than a pay period.
Right.
So we've heard whispers from the Secretary of Labor that they're going to more broadly define furlough, so it lasts more than a pay period. Right now, we don't have that guidance, but the expectation is that it's going to be a more loose application of furlough than that 2003 opinion letter, because a DIR letter is not a court opinion, it's just an opinion. So in this crisis, we expect furlough is going to be able to last a little bit longer than a pay period. Okay, EEOC guidelines, Equal Employment Opportunity Commission guidelines on COVID-19.
Now, EEOC is the federal agency that prohibits discrimination against protected classes, right?
Correct. That's the federal agency.
Like FEHA for California. No discriminating against a woman, or gay, or color, or race.
All of that, all of that. So EEOC is federal.
Disability.
FEHA is disabilities in there too. There's about over a dozen of them.
Yeah.
And FEHA mirrors in a lot of ways EEOC, but is typically much more strict than EEOC. EEOC, they have been pretty consistently following the same EEOC guidelines when it comes to COVID-19 though, which is why I bring it up. Okay. So what can you do under the EEOC and what you can ask employees in the workplace if they've had COVID-19, if they've been tested, and if they're experiencing any symptoms. That has not changed. What has changed is that they can now check temperatures of employees entering the workplace. If an employee refuses their temperature to be taken, you can send them home without pay, unless they can telework, right?
Right.
And now, can somebody single out an employee? Thank you. That's why I got you here. I appreciate you. Single out an employee for temperature. If oh, that person looks kind of sick, I'm going to take that person's temperature. Yes, you can, but be careful because I expect also we're going to have a lot of discrimination types of suits coming around the corner of how we're treating people differently, whether they're in a COVID-19 type of risk area, somebody who's older than 65, somebody who is pregnant because they're high risk. There's been a lot.
So you don't want to do the Harvey Weinstein temperature check, is what you're saying.
I don't know what that is, and I don't want you to say it.
I don't know what it is either, but
okay, good. Anything that starts with Harvey Weinstein cannot end well. But you can do, and the less invasive the temperature check, which you just bring up is a good point, the better. They have ways of temperature checking without ever touching somebody. So that is a preferable way of doing it. Let's see.
I know this one.
What?
You can disclose the information. You have to protect the privacy of the person. Now, it sounds like an employee comes up and says, "Hey, Bob's coughing." You can't. You can identify to everyone in the company that someone is coughing or that areas that there may be an issue, but you can't say who it is.
Right. So you have to protect the confidentiality to the extent you can, especially if it's a small workplace. It might be difficult.
Or if he goes home, you can't say,
"Yep,
Bob's got coronavirus."
Yep.
You have to say, "This employee is teleworking." But we are not going to say why.
You don't say why. So that sums up this slide. So I'm going to move on. You did a great job. Yeah, I like that.
I'm trying not to screw up as an employer. It's hard. It just basically just sit there and don't do anything. And give everyone leave if they ask for it.
And that's
or if they don't.
Most employers get frozen because they're afraid of doing anything wrong.
Yeah.
And last time we said, hey, don't take a temperature because it's not a direct threat.
Mm-hmm.
And then a day later, CDC said, okay, you can take the temperature now. It's a direct threat. So it changes, and I understand why people get scared to make these types of decisions.
Right.
Now,
can't send them home if they're old or pregnant.
I got a lot of these questions at the beginning of coronavirus,
mm-hmm.
and this was without the guidelines. I said, you do not, and I didn't have to even get the guideline. Do not send an employee home because they're older. Do not send an employee home because you think they might be high risk. Do not send an employee home because they are Asian. And these are the types of things that have been happening with media issues and people pointing fingers. We as employers need to put a stop to that. So do not single anybody out because of those reasons.
It makes sense. You were the oracle. You're a little bit of an oracle in that situation there.
Yeah. If one thing I do know, don't send somebody home because they're older, for sure.
Yeah. Or really for any reason other than they have coronavirus.
Right.
Yeah.
Telework issues. Just briefly. I want you, and we talked about this earlier. Track the employees who are working at home when they are working. Have a clock in, clock out system. There are companies that have these great systems. We use them, like ADP, where they, when they're logging onto the computer, how much time they've worked. They get alerted when their lunch break is happening and they have to log off. I love that idea because we are complying with California law, meal rest breaks, and it's being tracked. So I highly recommend you do it. It might be a little bit more expensive to do, but I think it will save you money in the long run. Reimbursements, make sure they get their pro rata reimbursements, have them submit reimbursements of all the work necessary for them to do at home.
We send them a check for a certain amount of money based on an estimate and then respond to any inquiries. But you got to do that. A lot of people don't know you got to do that proactively.
Yep, and you have to give them the opportunity and do a flat rate, giving them the option, if it's more than this, if it's more than $40, $50, whatever it is, submit your expenses, and then we'll take a look at it. If it's a reasonable expense, we'll pay it. And I think, did we finish? Yeah, that's it, everybody.
Give me another slide. Thank you.
No,
This is
that
our
one, the
finish
important
slide.
one. There it is.
Yeah, so this is, thanks, Eric, for doing this.
Of course, I enjoy doing this.
This is such a crazy world we're in, and I think we've given a lot of really good information here. Just as a reminder, it's going to be every Thursday for me for an hour. I keep you up to date and in depth on a topic in workers' comp until we work through them all. And Eric, I'm sure we'll be hearing from you again.
Yep, I will be also joining our partner Keith Figgins on Friday at 10 a.m. on Facebook Live.
Yeah, his half hour a week Facebook Live. Let's talk about
Yep.
comp and coronavirus.
And I'll bring a lot of the questions that we're getting there, and we'll talk a little bit about some questions and answers for employment law issues.
Very good. Our contact information is here. So if there's any questions at all, please forward them. Last time we were able to answer them all. And with that, I'll thank you, Eric, and we'll finish up. I hear your alarm is going off, so that's it.
Thanks, you guys.
Okay, bye.